Chris Tremaine.
I move that the question be now
I'll
put.
hear Carol Beaumont.
Much, Mr Chair, it's a pleasure to talk on Part 3 of this Courts and Criminal Matters Bill. As others have mentioned, amendments to the Summary Proceedings Act 1957. This is actually a fairly substantial part of this bill. Quite major things covered, quite a large section of service under this part. Then another large section on disclosure of default balances to certain authorised persons, which is the credit reporting part that a number of speakers have been recently talking about. Then there is a huge section on seizure, release and sale of property. So there's actually quite a lot in this part of the bill. I wanted to talk about two things really. First of all, the bit that my colleague Lynn Pillay has talked about, and that is the credit reporting, or the service under this, not the service under this part, the credit reporting element, which is about the release of overdue penalty balance of eligible people into the private sector credit industry. And the Honourable Rick Barker, when he spoke before, I think made particularly good points around the fact that debt to the Crown was perhaps harder to ascertain than debt to private sector organisations, and that didn't seem right. And so this part really deals with that. It provides for a credit reporting scheme. Importantly, it doesn't include those people whose penalties are not overdue, and including those subject to a payment plan. And I think, as Chris Hipkins talked about in the previous part, that's very important, that when we have got people who are finally taking responsibility to pay back the fines that they owe and have come to some agreed arrangement, then they shouldn't be further penalised. And we all know at the moment that it is tough for people to make ends meet and that people can easily get into debt situations. And the important thing is that they actually do come to an agreed payment plan where they are contributing that money back. So I think that's important that that's specifically precluded from this credit reporting scheme. Now, the Ministry of Justice are authorised under the bill to use the information from the credit reporting agencies, such as updated addresses and so on, to collect fines. Now, the bit that I was interested in was also this bit around the Privacy Commissioner, and the Honourable Rick Barker mentioned this bit as well. And it says that the bill requires the Minister of Courts to consult the Privacy Commissioner before recommending any regulations implementing the exchange of information between the Ministry of Justice and the credit reporting industry. Now, when I look at this bill, I see that this was actually quite a significant matter dealt with by the Select Committee, and that in fact the Regulations Review Committee actually had quite a lot to say about this. Now, it's been something interesting as a new Member of Parliament to see the role of the Regulations Review Committee, and it seems to me that it is very important actually that the work, I have to agree with you, with the member opposite, that it is important work and that somebody does need to keep a very close eye on the powers that are given to make regulations. Now, as I understand it, the Regulations Review Committee expressed concern that the regulation-making powers in this part were potentially with high policy content which could infringe the right to privacy, and in fact they also felt that it would allow regulations to be made which could override the general provisions of the Privacy Act. And so consequently the Select Committee clearly thought about this quite long and hard, and it does require the Minister in this part to consult with the Privacy Commissioner before recommending any new regulations to the Governor-General. That was further strengthened by amending Clause 69 to require the Minister for Courts to be satisfied that any proposed regulations were consistent with Section 92B. And they also went a step further and amended Section 92A by amending the definition of recognised user. So when I look at this part of the bill on page 74, there's quite a lengthy provision there about the sorts of matters that the Minister, that the Governor-General may, by order of Council, made on recommendation of the Minister of Courts, make regulations for, and then there's a lengthy list of things. So it does seem to me to be quite important, because some of those include some quite serious matters, Mr Chair, including prescribing the period for which fine status responses may be retained or used by recognised users and subscribers, and requiring the destruction of those responses on the expiry of specified periods. It's really important, I think, that individuals have confidence that while they have some responsibilities, and this bill is about making sure that people fulfil those responsibilities to pay fines for things that they have done, that they also have some rights and there is some balance. And I think there's quite a lot of thought both by the Regulations Review Committee and then the Select Committee in trying to get that balance right, and quite a lengthy provision here. So I certainly feel that that was good work done by the Select Committee. They didn't actually go as far as the Regulations Review Committee would have liked. However, it says we do not propose adopting the Regulation Review Committee's suggestion that the bill be amended to require confirmation by Parliament of any regulations made under subparagraph H that overrode the general provisions of the Privacy Act relating to the use and disclosure of information. So I think they tried to take account of the concerns, come up with some reasonably robust provisions, but they certainly didn't go as far as what the Regulations Review Committee would have liked. The other thing I found interesting in this part of the bill is the bit about service under this part, and not something I know a great deal about, but I was quite interested to see quite how extensive the provisions are here. So it both talks about the various ways that you can serve a document, and whether that's personally or by mail or electronically or anything else. But interestingly enough, it has a whole section on the mode of service under this part modified in special cases. And I thought, well, I wonder what they are. And it includes situations where somebody is living or working on board any vessel, including any vessel belonging to the Royal New Zealand Navy, by an authorised process service delivering the document to the person on board at the time of service who is apparently in charge of the vessel. So it even goes as far as talking about serving notices on ships, and indeed to members of the New Zealand Armed Forces, although there will be less of them, of course, because we've just seen quite major cuts into our defence forces, but nonetheless those that remain may have something served on them by delivering the document at the barracks, camp or station to the officer for the time being in command of the unit or detachment to which the recipient belongs. So I did think it was quite interesting just how detailed this legislation is in regard to the service of these documents, both the way that it's done and in special circumstances, as some of the ones that I've just outlined there. Now, finally, the area that is in this part that is quite significant, I think, is what is called the super priority, the seizing of property. And this is where the district court can obtain higher priority over secured property of a credit provider if the loan was advanced when the overdue penalties could have been released under the credit reporting proposal, and when that property is subsequently seized by the court, some or all of these discoverable penalties are still overdue. So this is situations where lenders, for example, can check registers and so on, but the court will retain this higher priority over secured property. So I didn't go into a lot of detail in looking at that bit, but I'd be interested in hearing more about this super priority that is provided for in Part 3, which I've just been speaking about. Thank you very much.
Mr. Chairman. Dr. Cam Calder.